Hello, hello. I'm Sivonnia DeBarros, protector of athletes and the owner of the S.L. DeBarros Law Firm. I'm really excited to be here with you guys today to talk about 4 things you should be doing if someone is copying your brand. And listen, don't think that it can't happen to you because it can and it will, but the way that you respond, how quickly you respond will be the difference between you losing the rights to the name of your brand, okay, or not. Now, before I dive in, let me just share a little bit more about who I am. As I've stated, I am the branded protector of athletes and the owner of the S. DeBarros Law Firm. I help athletes and entrepreneurs to increase their business profits through boosting or by boosting their legal protection. And most times that is through business support, contracts, trademarks, and at times that means I have to go into court and actually argue cases. All right. And so sometimes that is the last ditch effort for my clients to definitely show their hand, their power in protecting their brands. So, with the job that I have, the way that I serve my clients, let me just say this because it's not to be bragging or anything, but I am proud of the advances in business that I've been able to make and the impact that I've been able to make with what I do. And so that has put me on platforms like CBS, ABC, Fox, WGN9, and have garnered me the opportunity to be the expert that has provided quotes for major magazines like Forbes. There's a lot, and I can't remember all of them, but let me just say this: you are not just talking to some lawyer who thinks they know something. I do know what I'm talking about. All right. So I want to help you to protect your brand. And what I'm talking about today is one of the key ways to make sure that you are absolutely doing that. Now, previously, when I did a live, I talked about some of the mistakes that entrepreneurs make with their brand. And I also delved into just a little bit about the importance of policing your brand. And so today's topic is going to basically be kind of fleshing out that idea of what it looks like to police your brand. All right. So we're going to dive in 4 things to do when someone copies your brand. All right. So here we go. I want you guys to get your pens and paper together so I can give you these tips. And before I share this information, I do want to invite you to my masterclass that's happening on the 20th. The 21st, excuse me, the 21st of this month. So the Trademark Masterclass is happening the 21st of this month. You can register right now at bit.ly/TM Masterclass. That is all caps, and use code New Year before the 14th to take advantage of our promotional rate. Okay. So again, bit.ly/TM Masterclass and use code New Year without a space to take advantage of our promotional rate. All right. So are you guys ready to dive in? Are you guys ready to dive in? I surely am. So 4 things you should be doing when you recognize someone is biting your style, so to speak. Let's use that. Someone is biting your style. What should you do? Someone is just like blatantly taking your stuff and was like, "Oh, this is dope. I'm just gonna use this like it's mine." What are you gonna do? You're gonna call your friend and just be mad about it? You're gonna cuss and fuss all over the place, or are you going to actually take action? Because that is essentially what matters, right? Of course, it'll piss me off too if someone was using my stuff, but the way we respond to things is it shines a light on what the potential outcome possibly will be. All right. And so let me share my screen with you guys. Let me see if it will come up for us. All right. Because I want you to see a depiction of what you should be doing. Okay. All right. So is someone copying your brand? Is someone copying your brand? If they are, then it's time to take action. So the first thing that you are going to do when this happens is you are going to issue a notice of infringement and file your DMCA takedowns. Okay. So what that means is if I say, okay, I'm going to issue a notice of infringement, one, that means I'm just letting that person or company know that, hey, you're violating my brand right now, like my registered marks, and I'm going to need you to stop doing that. If you've recognized that the infringement is on certain platforms where it allows you to file these, what we call DMCA takedowns, you can file an application with those companies through their particular protocols to ask them and show proof like, hey, I actually own the registered marks to this, or I own the copyright rights to this brand, and this person is effectively breaching or infringing those marks. Then you can also do this in conjunction with issuing a notice to that other party that, hey, you're violating my rights on this. Okay. So that is the very first thing you would want to do. The reason why you want to do this is because if you allow people to linger around and use your brand without notification, you are not policing your brand. You're not stepping up for your brand. And that is absolutely critical to maintaining the protection that the federal registrations give you. All right. So issue notice of infringement and make sure that you file your DMCA takedowns. Now, next thing you are going to do is send a demand to cease. Send a demand to cease. So entrepreneurs, even those who are not lawyers, have heard a cease and desist. Should I send a cease and desist, right? You don't need to send a cease and desist for every single thing, but you can send a demand to someone, a letter that says, hey, I've sent you this notice of infringement by whatever method you've sent it, whether it's email, you've sent it through some kind of social media handle or messaging app, or you've mailed a letter to notify them that there's infringement and they need to take it down. You can actually send your notice with the demand itself. Okay. So you can do both as one, and you can do it separately. So when you send the demand to cease, you're saying, hey, I have the federal rights. I am the only one who have the federal rights to this brand or to this copyright material. And by you utilizing it, you are not only infringing my mark, but you're costing me money. Okay. You're costing me money, or you're going to cost me future damages if you do not stop today. So now your demand can ask them for, one, the action of stopping, which is ceasing, right? That particular conduct that is injuring you. And you can ask them for money, right? You can say, well, hey, my brand is a multi-million-dollar brand. And by the sheer nature of you copying my brand, you are diverting God knows how many potential customers away from my business. And therefore, I'm demanding not only that you cease this conduct, but I'm also demanding that you cut me a check for another like $20K or whatever. Because let's just face it, if any business owner filed a case, especially around trademark infringement or copyright infringement, you're still looking at like hundreds of thousands of dollars over the span of time just to litigate these matters, because you're talking about federal rights, number one. So you're in a different field of practicing versus, being in state court where things may not be as heavy. You literally have to show up in federal court with the proper lawyers, with the right arguments, and you have to show how this infringement is absolutely killing your business. Okay. So you're going to issue your notice of infringement. So I'm just going to back up really quick, because when you issue your notice of infringement, I want to clarify for you that sometimes this is not a very official letter. Your notice could, like I said, it could just be you saw this on social media, and so you went to their DMs and were like, hey, I saw that you have created this particular program with this name, X Mark, which is my actual brand that I have a registration for, a federal registration, a certificate of registration, and it's imperative that you stop using this right now, right? But then you can also turn around and go to those places to file your DMCA takedown. So let's, for example, if someone uploaded a video of you speaking, and you know that the speech that is on or in the marketplace is something that you sell that is proprietary to your company, you can go to whatever platform that would be and ask that company, the platform company itself, to take that infringing material down. Okay. But let me just tell you, you still have to show proof that it's your particular proprietary information to support them in taking it down. And then next, to recap, you will send a demand to cease. So if you don't see any action, especially on the part of the other party, and they're constantly using it in spite of the fact that you've been successful in DMCA takedown notices, you should be issuing your demand to cease their infringing conduct. So the next thing you're going to do is you're going to follow up on the demand for compliance. So typically, when I draft demands to cease the infringing actions, I put in deadlines where they have to respond to me by, or at least notify me that they have my letter. And typically, it depends for me. Now, I'm just speaking for me. Typically, it depends on how urgent the matter is. I might give people seven days, sometimes 14 days. I never try to extend it too far out. But if opposing counsel reaches out to me and they seem to be a reasonable and civilized individual, and they're like, hey, I'm just notifying you to let you know that we have received your letter. However, I'm going to need time to look through this and get a proper response to you. Cool. I'm good with giving them that allotted time, but don't get it twisted. Don't allow someone to take advantage of the time that you're giving them. If they have ignored the timeline that has gone by, then you're going to want to move to your next step, because at the end of the day, it is about being civil to each other. And if you are an attorney watching this, it's about trying to take the best approach for your client. Okay. But it don't mean that you got to sit there and be nice and just allow the infringing actions to diminish the protection of the client's mark. So if you're an individual entrepreneur, business owner watching this, and someone reached out to you and said, hey, I have your demand, please give me a little bit of time to review this and get a response back to you, you're going to want to know, well, how long of a time do you need? Because based on that particular length of time, you're going to want to put that in your calendar and make sure you follow up again to see if that full response has been provided to you. Now, this is going to help you do a few things. One, it's going to help you determine what your posture is going to be if it comes to the fact of you having to make a next move. And this is like literally the last option, moving it to the phase where most people don't want to go. And I'm just going to have to tell y'all, like, you're going to have to do it. I'm going to reveal what it is pretty soon. Okay. But this will show you not only how likely the other party would be willing to enter some kind of negotiations with you. It could be something a little bit more informal, but still maybe having the urge to come to the table to resolve the differences versus resorting to something more financially costly, like litigation, for instance, because people know, especially if you're dealing with an attorney on the other end, they know that there are no guarantees once you file a case, right? So everyone could be spending money, but we don't know where the cookie may crumble. The other thing this does when the other party follows up with you with their response or lack thereof is it shows you the position that they're taking, okay? So it is very important that you don't approach this from a very emotional space. You need to approach this from an objective space, and from a place of strategy. So if you do end up with a response, you want to like really read through the lines of what that response is, because it will tell you, it will give you telltale signs of the position they possibly would take if you did decide to actually file suit. All right. So who can guess what the next what the next phase is? Who can guess what the next phase is? All right, if you're watching this, you probably already know. You gotta sue their bleep. You gotta sue them. I'm just Taylor. Listen, I'm just the messenger, okay? But at the end of the day, what is your brand worth to you? If you've issued a notice of infringement and filed DMCA takedown notices and no one has responded, right? Regardless of the fact of your successfulness in removing any infringing material on social sites or video platforms or whatever the platform may be that the individual doesn't control, and then you send a demand to cease and they ignore it, or they are like they're not doing anything that is in line with making sure they're worried about their own company, their own brand, right? And then you follow up with them and they don't respond, or let's say they do respond, but their response is very lackluster, or basically, whatever, we're not studying you, or they might say, well, go ahead and sue me if you want to. Well, you know what you might have to do? You might absolutely have to sue. I mean, let's just keep it 100. You might have to sue. Now, here is the thing about filing suit. It is a power move, y'all. It is a power move. One thing I absolutely like, it really gets on my nerves, is when entrepreneurs are sitting back so seemingly scared of filing suit. If you are not the first person to run to the courthouse and file your case, and that other person does because they want to try to get a hand up on you, it's possible you could lose the strength of your mark, right? So all of these steps are just ways to help you protect the brand that you have if someone else was copying your brand. Because the danger you fall into is, one, how long has the copying been going on? If you haven't even seen it before, this is your first time kind of seeing it, but these people might have gotten some kind of may have gotten famous in their particular industry around this particular mark, and you haven't said anything until now. You might be on the cusp of losing that protection of your brand. And so when you file your case, you really are flexing your muscles to let them know, listen, I ain't playing with you. I'm not playing with you. And I'm going to say this, it's much easier to play offense than defense when you're in federal court. Let's just keep it real. It is easier to play offense than defense. So not only can you really flex your muscles and show individuals and companies that you are not the brand to be messed with, like, I will sue you. That is the type of persona you have to have, so people think twice when they just want to go and throw your logo out there somewhere, or copy a brand that you have, or copy some workshop or educational material that brings or racks in hundreds of thousands, if millions, if that, of dollars. Okay, so to recap, if someone is copying your brand, 4 things you should do is issue a notice to them that, hey, you are infringing my mark. File DMCA takedowns. Send them a demand to cease, but make sure you follow up on the demand for compliance, and don't wait forever for them to respond to you, and make the critical decision. Is this the moment where I need to file suit to protect my brand and to really flex in my industry and let people know that I am not going to allow you to ruin my brand and to technically damage me financially by swooping in and taking the customers away from my company? All right. So I hope this has been beneficial for you guys. And as always, like, I really love talking about this stuff. I love educating entrepreneurs and business owners because I do recognize that at times people just want to hide the ball from you. They don't want you to know what you need to know. But this is not a replacement for hiring an attorney. All right. So when you have an attorney, you have a legal team, you are able to focus on the things that make sense for you. And while also having dedicated support to go in and to really run those strategies the way that they need to be ran to protect your brand. And by protecting your brand, helping you to increase your profits. All right. So join me January 21st for the Trademark Masterclass. You can register right now at bit.ly/TM Masterclass, all caps, and use code New Year without a space, also in all caps, to take advantage of our promotional rate before January 14th. I'm Sivonnia DeBarros, protector of athletes. And until next time, guys, I will talk to you later. Ciao.